So, keeping a position of epistemic doubt, perhaps of epistemic humility, is one way out of the problem, but it doesn't fully solve the problem. I want to talk about two other angles for a progressive pluralist to adopt, approaches that might offer some help. First, I will talk about the US doctrine of freedom of expression and the, in my view, cognate doctrine regarding government speech. Both, I believe, are examples of a commitment to a broad pluralism. And the questions are, what are the grounds for this? And whether such grounds can work as well for the larger dilemma faced by progressive pluralists. Then I will talk about my book, Against Obligation, The Multiple Sources of Authority in a Liberal Democracy, and whether any arguments against political obligation and legitimacy, and for what I call permeable sovereignty, can help us resolve the larger dilemma I am addressing. After discussing these two angles, I will return to where perhaps we all must return in these debates, to pondering what type of regulable harm is appropriate for the liberal state, and whether a robust commitment to pluralism requires an adjustment to how we think about regulable harm. I'm now switching from T to Dasani. Someone at the Coca-Cola company made a lot of money coming up with this name. And they must have vetted a lot of possible names for this, Dasani. Okay, I teach an upper-level course, a law school course, on the First Amendment. I cover speech, press, and religion. Pretty much the first thing I say is that we in the US have strong protection for expression in spite of the fact that speech can cause real harm. The so-called free speech principle is about just that. What is specifically important about speech that leads to our protecting it in the face of legitimate state interests to the contrary? So we discuss the standard affirmative arguments, marketplace of ideas, promoting democracy and personal liberty, and see that although each contributes something to grounding a strong free speech principle, none alone nor all of them together can fully justify the strong protection we give to expression. We then discuss what Fred Schauer has called an argument from negative implication, which is an argument about distrust of the state to regulate in these areas. I'll return to that. First, though, I want to describe some of the very real harms that our case law deems insufficient for speech regulation. Privacy. In several cases, the court has voted for the press or other speakers as against various privacy claims. Thus, it has invalidated state action that would discipline the press for publishing the names of rape victims and for broadcasting an illegally obtained, otherwise private conversation between two labor union leaders. And it struck down a jury verdict for intentional infliction of emotional distress brought by the father of a Marine killed in action against a church group that protested near the funeral, saying that God was punishing persons such as the Marine because the US has adopted a sinful view about homosexuality. Granted, in all of these cases, the court noted that the subject matter of the speech was of public concern, although how the name of the rape victim met that criterion is hard to see, and has suggested that publication of purely private matter might be regulable. Offense. In a courthouse corridor, Paul Robert Cohen wore a jacket that said, "Fuck the draft." Across from the Republican National Convention, Gregory Lee Johnson burned a US flag. And a drive-in movie theater, anyone been to one of those? I won't ask what happened while you were there, but showed a movie with some images of nude people, visible not only by paying customers, but also by people driving on nearby roads. The court refused to allow regulation of any of this, despite the deep offense that some feel from seeing the expression in question. Hate speech. Oddly, there is no clearly canonical holding of the US Supreme Court on this issue, But it's clear from various things the court has said and from lower court opinions and from scholarship that the worst kind of vile hate speech is fully protected in the US so long as it is made in the general political arena and doesn't constitute incitement or threat or face-to-face fighting words. Here's my main point about all of this as it relates to the subject at hand. Even when we're confident that certain ideas are wrong, false, evil, harmful, we allow them to be expressed fully and wholeheartedly. I appreciate that some of this is controversial, and that in some nations, some of the speech I reference, in particular some hate speech, is regulable. But in the US, the liberal progressive commitments of universal human rights advocates, to the extent they advance equality arguments for regulation, have lost to the pluralists, who have insisted on permitting even the most clearly false and potentially harmful speech. Now, perhaps one might say that liberal progressive values are themselves in conflict here, and perhaps that's true. But another way to see it is as a victory for a certain type of pluralism over certain types of comprehensive liberal commitments. The distrust of government argument plays a key role here. Of course, one could advance such an argument opposing any governmental regulation, but it plays a special role in supporting the free speech principle. The claim is that particular perversities, if you will, arise when the state regulates speech. The temptation is too great for the state to regulate disfavored ideas while protecting favored ideas. For example, when I teach the class and ask whether we should permit regulation of what some call radically subversive speech, this is a term of art for speech that would put into power those who would take away speech and equality rights from others, think skinhead neo-Nazi groups. Students invariably respond with a concern that if we let the state regulate such speech, inevitably the state will have too much power to regulate simply disliked speech, and that we will be unable to draw appropriate lines. Granted, there are affirmative value arguments for permitting such hateful speech, but the distrust of government argument is powerful. Although such an argument isn't the same as the epistemic uncertainty or humility argument for pluralism, for grounding pluralism generally, it's at least a first cousin. The epistemic uncertainty or humility grounding for pluralism is a first-order matter, actual doubt regarding truth. The distrust of government argument regarding speech regulation is a second-order rule. Even with no doubt about an idea's falsity, we permit its expression because of doubt about the ability of the state to make these judgments without what we might call political bias. The connective tissue between the two groundings provides some heft for strong pluralism, both involving a kind of parsimony of judgment. One can also see a robust pluralism at work in the justification for and practice of state speech. The connection to the progressive liberalism versus pluralism dilemma and to freedom of speech generally is this. There are good arguments for state speech as being almost entirely constitutional, even if it is controversial, and even if it pushes one over another contested view of the good. One can be a liberal progressive regarding various issues, such as LGBTQ and reproductive rights, and still think it appropriate and often good for various state actors and entities to advance their own, often differing views on these subjects. I'll say some more about this now. I have endorsed the view that the state may speak and pay agents to speak, not only to promote relatively uncontested matters of science and public health and the like, but also to advance what may be contested views on social issues, indeed to advance positions in such debates that may stem from deeply contested and comprehensive philosophical or ethical notions of the good. The state speaks for us in ways that we sometimes fail to do for ourselves, and the position of the state as a public collective entity is different from the position of private actors and individuals. Thus, the state may seek to promote a certain way of viewing the environment, a way that has its roots in deep and contested positions about stewardship and what we owe future generations. It may seek to promote a specific conception of democracy, at home and abroad, and counterpose that conception not only against other conceptions of democracy, but also against, say, communism or socialism. It may advocate for a wide array of school choices, or it may push for the opposite, a public school that everyone attends, push for but not insist on. These are just some examples of how the state may dig deeply into the foundations of contested social policy matters and advance not only social science-inflected instrumental arguments on behalf of such positions, but the philosophical or ethical roots of such arguments as well. The thinner view of liberal democracy, that the state should abstain from promotion of contested views of the good, is a poor fit for the US constitutional order, and I'll venture to say for the constitutional order of any liberal democracy. It's sometimes, the thinner view, sometimes relies on the incorrect idea that citizens will defer too strongly to the state. Why? So long as the state is transparent as speaker or funder of speech, citizens will know whom to blame, so long as the state, and can give credit or critique as they do with any source of speech. It sometimes relies on a too libertarian view of liberal democracy. Whatever one thinks of hot debates about state regulatory authority, state speech power need not be limited in the name of liberty because the state is just one speaker, and if just speaking is not acting coercively. And it sometimes takes a Rawlsian notion of public reason too far, believing that reliance on comprehensive philosophical or ethical views places the basis of state action beyond generally accessible understanding. Why should we believe that, though, about non-theistic positions? In short, there are good reasons to think broad government speech is at least permissible, and perhaps also to think it is advisable. In closing this discussion of expression, both by the individual and the state, note that the combination of the two advances a kind of pluralism. By allowing a wide variety of individual speakers, even outliers and dissenters, we encourage a kind of centrifugal multiplicity of views, often challenging agglomerations of power, both public and private. State speech can serve as a centripetal counterweight to this, advancing commonly held values, or at least as deemed so by the state actor or entity in question. The US approach to private and state speech represents one arena in which progressive liberals can find their way to supporting strong pluralism. But what about a broader argument that would challenge the baseline of state power as presumptively legitimate and deserving of obedience, while also establishing an affirmative position supporting multiple sources of normative authority? This is the argument I advance in my book Against Obligation. Even in a liberal democracy, we don't have a presumptive moral obligation to obey the law. This is my take on the old question of political obligation, and it takes up the first chapter of the book. One may divide the arguments for political obligation into three types: agent-centered, state-centered, state-based, and, agent-centered, status-based, and state-centered. For each type of argument, I am asking and answering a question at the following level of generality. Does one have a moral duty to obey all laws all the time as a prima facie matter, subject to case-by-case override? The state claims authority in this general presumptive way. It makes a content-independent demand that we should obey the law simply because it is the law. Granted, there are normative arguments behind this demand, arguments I summarize in a moment, but the demand is neither law-specific nor application-specific. Agent-centered arguments look to acts by a state's subjects that may qualify as grounding a moral duty to obey the law. I discuss and reject express and implied consent, including residence plus benefits, the duty of fair play, and political participation. One of the problems connecting these arguments for political obligation is that although they are powerful when they obtain, they don't often obtain. And when they do, they may generate obligations narrower than a general duty to obey the law. Status-based arguments for political obligation focus on a particular role or position one has. I first evaluate a Rawlsian argument based in a natural duty to obey the law of a generally just regime. A core concern of mine is Rawls's baseline of so-called reasonable comprehensive views forming an overlapping consensus. This trades off of a comprehensive liberal understanding of what is just and reasonable, failing to give appropriate concern to religious and philosophical views that abjure Enlightenment rationalism. Next, I consider arguments from what is sometimes called associative obligation, that we have a moral duty to obey the law based on what we owe our fellow citizens. A central concern of mine is the improper extension to fellow citizens of the kind of loyalty we may owe to family and friends. And as with some consent-based arguments, here too we may owe some obligations to fellow citizens that are short of a general duty to obey the law. Finally, I use the term state-centered to refer to consequentialist systemic arguments for political obligation, the type you're most likely to hear at a cocktail party. What if everyone did that? I discuss the problem of self-dealing and the virtues of settlement, concluding that although each should be part of what Fred Chauer calls critically rule-sensitive particularism, neither can undergird the general case for political obligation. The case I make isn't just against political obligation. I also defend a version of political pluralism that I call permeable sovereignty. Some of us adhere to norms other than those of the state's laws. There's no good reason to treat such other norms, religious, philosophical, family, clan, tribal, as subservient to the law. We should see each of our sources of value of how to live as at least presumptively on par with each other, even though in some circumstances we'll have to let our separate norms go and adhere to the law. We should see sovereignty as permeable through to our plural sources of obligation rather than plenary in the state and its laws. I make my case against political obligation and for permeable sovereignty together. One of the reasons we should reject a moral duty to obey the law and the state's claim that it is justified in demanding we obey the law is that we shouldn't understand the law as having pride of place over other sources of norms. Seeing all sources of norms as on equal footing requires the state, when it can, to accommodate ways of living different from those dictated by law. If one accepts the argument against political obligation and for permeable sovereignty, for the view that the sources of authority in a liberal democracy are multiple, then one has shifted the baseline presumption from the state's law should be obeyed unless you can make a case for an exemption, to the state has to defend the law or application of law in question in any given case. This shifted burden helps with the dilemma faced by the progressive liberal committed to pluralism, by making any state claim to authority in need of justification and not presumptively justified. However, my argument is not for a full-blown anarchism, and it is not libertarian. It attempts to set the baseline differently and adjust the burdens, but it still gives the state the opportunity to defend its claim for uniform obedience, either for specific laws or for specific applications of specific laws. And although there is a case for deep pluralism in the area of free expression, arguably the kinds of harm we accept there are different from and maybe less than the kinds of harm present in the hardest cases confronted by progressive liberals with pluralist commitments. This is probably true for harm from offensive or vulgar speech. It's less clearly so for harm to privacy interests or from hate speech. Those harms are quite real, and to the extent we privilege expression over such harms, it must be because we value the expression highly, perhaps only by a generalizing move, for example, seeing hate speech as political speech, or because we distrust the state to draw consistent, unbiased lines. When we do permit regulation of speech based on content, it is because we deem the harm higher and perhaps the value lower, although I think more of this is on the harm side. Thus, when we allow regulation of political advocacy of unlawful action, it is in the setting of imminent incitement. When we allow regulation of threats, it is because the speaker has crossed the line from general political agitation to putting a specific person in fear of her safety. Thus, even in the realm of speech regulation, a nuanced harm calculus is central to our ultimate determination of how far we are willing to protect freedom of expression. Thus, the foregoing arguments for pluralism, from epistemic humility, from the speech model, and from the argument against political obligation and for permeable sovereignty, eventually run out. Although at the end of this talk, I will return to the latter, the argument from my book, as a way to achieve some resolution for our dilemma. We come up against specific laws or specific applications of law that are not merely about expressive harm, and where we are sure the law is protecting something of significance. And even if the state may not rely on the general case for obedience here, it may offer a more specific, tailored argument for uniform adherence to law and against accommodation. If the countervailing claim for accommodation is also strong, say, based in a clear religious authority and practice, then simply to bow to the state is to give up on robust pluralism. Since I am focused in this talk on laws supported by progressive liberals, if the state wins in all such instances, then one would be admitting that when push comes to shove, one's progressive liberal commitments trump one's pluralism. Unless one is committed to an absolutist position either way, then, there's no avoiding a more nuanced analysis of the harms in question and how they balance against the claims for accommodation. I'll suggest 4 types of arguments for regulating harm and how we might think about the balance in each setting. I'll start with what seem easier categories: direct harm to the body and paternalistic concerns. The former is an easy category for deferring to the state, the latter for deferring to the individual. Then I'll turn to the 2 harder categories: risk, regulation, and equality. Note that some of the examples I'll discuss pit progressive liberal values against pluralism. Some perhaps are general state interests not so easily classified as progressive liberal, but still standard interests of a liberal democracy. So first, direct harm to the body. We don't let people engage in human sacrifice, even if they claim strong religious, ethnic, or tribal norms. This is an easy case, but note that even with easy cases, we should pause and ask what we have just done. Here we are sure enough about our position regarding the good and hold a perhaps not fully worked out theory of vitalism or some other word capturing the ultimate value of human existence. Other regulation of direct harm to the body might not be so easy. Take the outlawing of female genital mutilation, FGM. Note that even the name for this reflects the conclusion of the liberal state that there is nothing to be said positively from a cultural perspective for such practices. I agree with this, but it's important to note that in agreeing, we are adopting a notion of harm to the body combined with a conception of equality that outweighs any claim the cultural group might have to the contrary. I use this example in part to contrast it with circumcision, about which there is no such settled liberal state norm regarding harm, and for which there are strongly asserted age-old religious arguments. So, here's the World Health Organization, WHO, on FGM. Quote, FGM is recognized internationally as a violation of the human rights of girls and women. It reflects deep-rooted inequality between the sexes and constitutes an extreme form of discrimination against women. It is nearly always carried out on minors and is a violation of the rights of children. The practice also violates a person's right to health, security, and physical integrity, the right to be free from torture and cruel, inhumane, and degrading treatment, and the right to life when the procedure results in death, close quote. And here's the WHO on male circumcision, quote, male circumcision is one of the oldest and most common surgical practices worldwide and is undertaken for many reasons: religious, cultural, social, and medical. There is conclusive evidence from observational data and 3 randomized controlled trials that circumcised men have a significantly lower risk of becoming infected with the human immunodeficiency virus, HIV, close quote. WebMD.com is more nuanced. It says, quote, the use of circumcision for medical or health reasons is an issue that continues to be debated, close quote. And then you could look at circumcision.org. I have no idea what that group is or who is behind it, but let's just say that their view and the WHO's view are not aligned. I'm not an expert on these issues, and I'm reporting it for this purpose. It's all about whether the liberal state has or doesn't have accepted science and norms. If it does, the cultural group loses. If it doesn't, the cultural group wins. That's an overly simplified way of putting it, but my point is that even for direct contact with the body, the value versus harm debate can be contentious, and previously backgrounded acceptance may yield to a more fractured argument. But for many regulations of the security of the human body, there is broad acceptance of harm that will trump more sectarian claims. On the other side is what I'll call merely paternalistic laws. Insisting that a turbaned Sikh wear a motorcycle helmet is an example, forbidding adult members of the Native American church from ingesting peyote as part of a private religious ritual another. Of course, both can be converted into not strictly paternalistic arguments. If a motorcycle rider is hurt because he wasn't wearing a helmet, his family will be affected and there may be other external costs for society. And the case for uniform peyote regulation includes an argument about drug diversion. But in both settings, the core argument for applying the laws to these particular persons is, as I see it, paternalistic. The state claims to know better what is in the adult person's best interests. And in both settings, the liberal state case for regulation should yield to the religious claim. Now let's turn to the harder categories, risk, regulation, and equality. For risk regulation, let's consider Kirpan cases, of which I know Canada has had several. Any regulation of carrying or wearing a sword or knife is a risk regulation because the mere wearing or carrying isn't harmful. The concern with wearing a knife to school is real, although more or less so depending on the nature of the knife and how it is worn and secured. Any rule against wearing a sword or knife in general or in school without exception is a victory for the regulatory side of things. The application of orange triangle slow-moving vehicle signs to the Amish is another instance of risk regulation that might come into conflict with religious norms about simplicity or plainness. Often we see religious groups and the state reach an accommodation that is acceptable to both. I consider risk regulation cases hard as a category because by definition risk regulation isn't about certain actions absolutely causing harm, but about balancing public safety and other needs against various countervailing claims. It may be hard to know statistically how much the risk is increased and of what precise harm should the state accommodate the often religious claimant. And thus to fail to accommodate, and even in my judgment to push hard for what may seem to be a compromise, might best be seen as a victory for the liberal state over a more robustly pluralistic position. Cases pitting equality norms against religious, cultural, or tribal practices are among the hardest to resolve. Hard for me, anyway. They arise in different settings. Let's first consider the market for goods and services. The US case of Masterpiece Cake Shop versus Colorado Civil Rights Commission involves a cake baker, Jack Phillips, who makes both generic and custom-made cakes. Citing religious beliefs, he refused to make a cake for a same-sex couple's, Craig and Mullen's, wedding celebration, although he will sell baked goods to gay men and lesbians otherwise. The commission held him in violation of Colorado Public Accommodations anti-discrimination law, which requires providers of goods and services to the general public not to discriminate on the basis of sexual orientation, among other protected characteristics. The primary remedy was to order Phillips not to discriminate on this basis. His case is now before the Supreme Court. One would think his core claim would be a violation of his right to free exercise of religion. But in Employment Division versus Smith, the court held that there is no presumptive right for exemption from laws of general applicability, and that only a highly deferential rational basis test applies when the state insists on uniform application of such laws. Since the Colorado law in question is a law of general applicability, that is, it is not specifically about religion, and the state has at least a rational basis for insisting on uniform application, Phillips will lose on this claim unless the court revisits the Smith precedent or somehow deems the case one of religious discrimination. His primary argument, thus, is that applying the law to him is compelling him to express his support for same-sex marriage. This is a complex claim about which a lot of ink has been spilled, including in an enormous number of amicus briefs. And I won't say more about it here, although I'm happy to talk to you all about it during Q&A. I've written a bunch about compelled speech as well as about the religion stuff, but I'm putting that aside for now. I'm interested here in the religion claim, which could arise in the US if the court reopened the Smith precedent, if state courts face similar claims under state constitutions with broad free exercise rights, or under applicable statutory law. I am torn about this case. My instinct is to want everyone to get along, as it were. For Craig and Mullins to get their cake elsewhere, there was no dearth of bakers who would serve them, and for Phillips to be able to adhere to his religious beliefs. I appreciate that one key argument to the contrary is to analogize to the race setting, in which virtually no one would want to grant an accommodation to a baker who refused to bake a cake based in religious belief about race, say, to a mixed-race couple getting married. But there's a case to be made that the cultural moment in which we find ourselves regarding LGBTQ rights is different from where we are or were regarding race, that Phillips's objection is not based in the same kind of animus as much racism is, and that things may work themselves out without the heavy hand of the law if we give it some time. My instinct to accommodate Phillips is based in part in there being other places for Craig and Mullins to get their cake. That market solution, though, doesn't fully address the equality harm to the couple, which is a core part of the case. By being told their business is not wanted by Phillips and that they must go elsewhere, they suffer an affront based on their status as homosexual. Although it may be hard to put a price tag on this harm, it is real and part of why these laws exist. So for me to follow my instinct through to accommodating Phillips, I would have to conclude that the harm to him from being compelled to provide the cake outweighs the harm to the couple from its denial. I'm not sure there's any other way around how to think about these cases. And I have another instinct here that goes the opposite way. Phillips is in the position of the classic conscientious objector, and he has three choices. One, disobey the law and take the penalties. I'm not sure what they'd be if he refused to comply with the court order to provide cakes for same-sex wedding celebrations. Two, adjust his business to providing cakes by appointment only, that is, no longer be a provider of goods and services to the general public. I believe this would mean he's no longer covered by the Colorado law. Or three, adjust his business in a different way by providing cakes to co-religionists only, which would also take him out from under the law. I assume that 2 and 3 would mean less income for Phillips. The point of this competing instinct is that if you're providing goods and services to the general public, perhaps you properly forfeit your right to discriminate based on your religious beliefs, period. That would be, please note, a significant victory for the progressive liberal side of things, although one might say laws such as Colorado's are really mainstream. The third option I mentioned, that Phillips could choose to provide cakes to co-religionists only, suggests that by remaining within an enclave, perhaps physical, perhaps metaphorical, someone such as Phillips may live more consistently with his religious beliefs. And conversely, that by choosing to be both a devout Christian with a certain belief set and a person who lives and works in a more integrated setting, Phillips must forfeit some consistency with his religion, must, in other words, compromise his beliefs and practices. Is that unfair to him? Is it proper to say to religious people that we will let them live by their own lights only if they stay away from the rest of us? This kind of exit from society is one way of ameliorating the otherwise difficult problem of political obligation and legitimacy that otherwise exists when the state makes categorical demands of obedience. Perhaps this is asking too much, though, and accommodations and exemptions can serve as representations of exit. Should it matter whether, in cases such as this, the affected same-sex couple or perhaps LGBTQ community writ large would see and understand an accommodation for Phillips in a sympathetic light, as relieving the baker of an otherwise scorching conflict of norms and obedience? State protection of equality norms also arises in a setting such as French laïcité and the ban on face covering. This is complex and various justifications are offered. I'm interested mostly in the argument that such a law protects women from discrimination within their own religion. Unless we have a thick view of false consciousness, though, it would seem this kind of argument should be off the table. It's one thing for the state to encourage a certain kind of assimilation and even to encourage religions to treat women fully equally. My strong view of government speech would allow this. But a regulatory ban on what clothing people may wear in the name of the state's best understanding of gender equality should be considered an insufficient argument to trump religious clothing choices of adults. Note, I say adults. The issue regarding children is more complex, because if we assume that children, at least up to a certain age, are not fully autonomous choosers, then we have to decide to what extent their parents versus the state get to make choices for them. This seems to me an under-theorized area of the law. I have mentioned 4 types of arguments for regulating harm when the state is refusing accommodation from generally applicable law for religious or other reasons based in comprehensive views of the good. The harms I've discussed are first order or direct, from specific persons to specific persons. There's another type of harm argument, though, that I'll term second order or systemic. The concern is that judges can't make consistent decisions about when to grant or not to grant exemptions, that there is a significant risk that their decisions will be influenced, consciously or not, by their sympathy or lack thereof for the beliefs and practices in the case. Or, and this is a different but related point, that their weighing of harm to claimant from exemption denial versus harm to a third party or the public generally from exemption granted will be arbitrary or at least not firmly enough grounded in principle. This type of second order argument was a key concern of Justice John Paul Stevens, who had a similar concern about legislative accommodations for religion. But if we are committed to protecting the values of political pluralism along with other values of the liberal state, then this second order concern would have to be quite strong to preempt categorically legislatively awarded accommodations or judicially awarded exemptions. One key problem for the Stevens position is that his conception of what one might call formal equality conflicts with a conception of what one might call substantive equality. To treat various religious, cultural, ethnic, and tribal groups equally, we must account for difference and for the neglect, or worse, that often is embedded in general law that does not otherwise make room for such difference. I have described several situations in which progressive liberal values, or perhaps liberal values more generally, come into conflict with political pluralism. Are we left with an intractable situation in which one side must yield to the other without a more general principle available to reconcile the differences? One way of putting this question is to ask whether Victor Muniz Fraticelli's claim of tragic conflict or tragic loss is correct. Similarly, Jacob Levy maintains, quote, that the tension between rationalism and pluralism within liberal thought is to a large degree irresolvable, close quote. Munoz-Fraticelli argues that the structure of pluralist arguments depends on three theses or claims. The first is about plurality of sources. The second is about incommensurability. The third is about conflict and genuine loss. About the third, he says, quote, "There is at least sometimes no way of resolving the conflict among incommensurable values that does not involve suppressing or giving up on one of those values," close quote. He adds that political pluralism accepts that the reasons of persons qua members of associations and the reasons of persons qua citizens may conflict, and, quote, "they may have no principled resolution," close quote. The incommensurability and tragic loss theses go hand in hand. I wonder whether they are correct, though. I'm reminded of Ronald Dworkin's right answer theory of legal interpretation. I know it best from its application to US constitutional law. The point is that even though cases may be hard, and interpretive sources multiple and conflicting and not transparent in what they reveal, we properly understand that for any case there is a right answer if only we could find it. I talked earlier about whether uncertainty was a ground for pluralism, and I concluded that it's part of but not the whole story. Now I want to ward off moving from the uncertainty created by truly hard cases to concluding that in such cases, principled resolution escapes us and there will be tragic loss in the end. As you can see from my seesawing regarding the cake shop case, I think it hard, and the right answer perhaps uncertain. But once we resolve it, do we think there is tragic loss, in part because of incommensurable values that we are unable to reconcile? Or do we think we can locate a more general principle under which apparently incommensurable values can be reconciled? Here is where maybe separating values pluralism from political pluralism can get us beyond tragic loss. Values may ultimately be incommensurable, but a liberal democracy can help solve its obligation and legitimacy deficit through recognizing sovereignty not as plenary in the state, but rather as permeable through to religious and other comprehensive views of the good. It can accommodate persons and groups who adhere to such competing views, and through such accommodation, provide at least a partial remedy for the otherwise unsustainable insistence on our lockstep allegiance and law following. Accommodations can be seen as representations of exit, allowing those whose norms differ from those of the liberal state to live within, but also exit from the state. In this way, liberal pluralism reflects a synthesis, not an opposition for our politics, even if not for our underlying values. Thank you. I think that's the longest I've ever spoken in my life. So.
Thank you very much.
You're welcome.
As is our custom, the first question will be asked by one of the student fellows at the Research Group for Constitutional Studies. I ask you for purposes of recording the question and the answer that you approach one of the microphones. I think that will probably be easier than passing them around.
Thank you all for your attention and patience. I appreciate it. And Victor, do you want the questioners to identify themselves, or is that not the norm?
I think that would be good, especially for acknowledgments later on.
Yeah, no, just, I don't know.
Hi, my name is Mila. I'm an MA1 in political theory at McGill. I had a question that kind of started bubbling when you started to talk about Barry and religious accommodation, just because what it looks like to me is that we're in this sort of problem, like this sort of issue that I think your solution is that we have state speech to try and guide people's values. But if our account of justice is going to include, say, the norms of like anti-discrimination, I guess what I wonder, and there have been responses to Barry on this too, that say what makes religion special. So some will just say it might have had a historically privileged status, what might just confuse us into making us thinking it's more special. But essentially, the state has to decide what constitutes a religiously acceptable exception. So essentially, the state is now in the business of deciding what is essential religious practice versus what's non-essential religious practice. So it's seemingly what people will argue is that it's the rite of exit that makes a difference. So that might make—
You mean real exit or exit through accommodation?
Yeah. So I guess the instance I'm thinking of is, say, for instance, the Catholic Church doesn't allow female priests. So that is not covered by discrimination law because they're exempted by that. Some might argue, well, women who want to be a priest don't have to be Catholic, they can exit the church. But that seems a little bit too complicated. So I guess if religion is special, then would you have us make it the case that discrimination is, say, not a big deal in religion compared to the other examples you cited that are not allowed, say, like female circumcision? So are there norms that might be like sort of less valuable to us that we're willing to concede over to religion? Or is your example of state-guided speech supposed to essentially work towards, say, like the church not engaging in discrimination? And if the state is in the business of—
I'm not taking notes. I hope I can remember all of it. Go ahead.
Sorry. And if
I may have to go back and forth with you a little bit to get this right. Go
Okay.
ahead.
So if the state is in the business of deciding, then how do we deal with the fact that, say, so if the state is controlling, or not controlling, but they're guiding us through their state speech, how do we deal with the fact that the state might represent the interests of the ruling class rather than actually represent what is just? And I guess that kind of relates back to some people's concerns about like the state controlling speech. So,
Okay, great. Mila?
yeah.
Okay, so a lot of threads there. So I guess just for the first one that pops into my head, because I didn't say much about it in the talk, although I know that people write about this, such as Jacob and Victor and others have addressed this, and I've addressed it a little bit in the book, is that when I asked you about what do you mean by exit, there's different things we could mean, and you were talking about exit from the group. Yeah. And so that's just obviously an important issue as a background or perimeter issue, all of this. And I guess I take on that I think the standard position that groups have to at least allow some sufficiently robust exit without penalty, that is, without physical penalty or property type penalty. And I know there may be some cases in Canada on this I'm not super familiar with about the property angle. So that sounds right to me. And again, I haven't worked through that, right? So, but with that in place, let's assume we have a religious group that does allow it, if it's adult members leave, they leave, and there's no physical harm or property harm, then I think that's the most we could ask from that. So that's just one piece of this. Although the issue regarding children, by the way, is incrably complicated.
Right, that's what I was
that we could talk about separately. I don't think anyone's worked that out exactly properly. Another angle on what you're talking about is the religion is special. So you may note that in this particular talk, I never said that. Now, there have been stuff that I have written papers sort of internal to U.S. constitutional law, arguing that there's a reason to treat religion as special, because we have also, in addition to the freedom of religion, we have the Establishment Clause, which is so-called separation of church and state, and the relationship between the Establishment Clause and the Free Exercise Clause is complicated, and I've done some writing on trying to work that out, where I do talk about religion as distinctive, and there I talk about belief in an extra human source of normative authority as being different from other forms of belief, but I don't. Didn't in this talk do it. In the book, I try to have it both ways. I have a section where I do talk about religion as special, but then I make a more general move. So for this talk, religion is an example, but it could be any other comprehensive view of the good. It could be a long-time family structure. It could be tribal. It could be cultural. So I just wanted to be clear about that point. On the state speech point, so yeah, I mean, I don't view state speech as a complete solution to any of this. I view it as part of the puzzle. And my view is, there are a lot of people for the world I travel in, sort of left of center constitutional law professors who really don't like my position on state speech, who think that it's way too thick. I do think the state can play a role, as you say, in encouraging even religious groups to change their norms, to read their religions in a different light. I mean, I don't think any of that's problematic. On your last point, on is the state just the product of the ruling class and not sufficiently committed to justice? That I think I probably often think that that's true, in fact, but none of my work reflects that because I'm not that kind of a scholar. I mean, and I don't teach that way either, although if I were to sit and have a conversation, I would probably say all those things. So I guess what I am is a romantic about this. I think that I want to encourage the state to be its best self and to speak for our best selves. So those are just a few, because you said a lot of interesting things, and those are just a few responses to them.
Thank you.
Okay. There's one over here too. Yeah, there's another mic if there's people over.
Okay.
Yeah, you thought I was like another person standing not at the mic.
Right. Hi, I'm Tanya Monfort. I'm a doctoral candidate here in the law faculty. And first of all, it was a fun talk. It was a lot of fun. And I was like going along with you on the theory part until you started getting into the examples. And that's why I started having a little bit more problem in terms of how...
I'm glad it was fun, by the way.
It was a lot of fun.
And there weren't even really jokes. My colleague, who's actually from a colleague of mine said that Americans supposedly are supposed to start talks with a joke, but I didn't have one, so go ahead.
Well, we'll get the jokes in the end, then, so it'll be even extra. Okay. And I don't know how many of them, but I'll get to at least the question of the race card, whether the race card is similar or not.
Yeah,
and
the hardest question. Okay.
Well, I mean,
it is. No, it is. Go ahead.
So, I mean, I guess one of the questions that I have is whether or not embedded in your theory, there's already a progress narrative. When you say that things
narrative?
Progress narrative in terms of you say that you think that things will work themselves out.
I did say that.
Yeah. So I don't know if it was written down or not.
No, it's in there right there. I haven't published it, but.
Well, because I was thinking back to Hannah Arendt's short piece, the essay on Reflections on Little Rock, where she's talking and she's criticizing the NAACP for their strategy of desegregation, of starting in the schools and not with marriage. But then she also has this whole aside where she talks about, but anyway, hotels and maybe community associations, there we can discriminate, right? Like people want to be with their own kind. And that's
Who's the author?
Hannah Arendt.
Oh,
right.
Yeah,
So
okay.
this is her radical, but also conservative, and there's this question. And so I actually think, things could have gone multiple different ways had the legal decisions not gone the way, the strategies, the advocacy strategies.
All right, and I should add, I'm sorry, what's your name again?
Tanya.
Tanya, and I should add to Tanya's point, including U.S. Supreme Court cases refusing to allow the freedom of association claims to win in the civil rights era, importantly connected to this. Yeah.
Okay. And so, yeah, so then I guess the question is it not kind of embedded into your, and I think there might be two assumptions. The one is that it's going to go in the progressive political way that you think it's going to work its way out, because it just kind of has to if we have some of the harder or easier cases are going to be decided legally with prohibitions. But then is it also that you are assuming that religion is in fact a special case?
So I want to put aside the religion as special for the moment, because this, in my theory, this could conceivably come up from a non-religious but otherwise well-established group with a set of norms. It just so happens that religion is the paradigmatic case. I'm going to sort of tack toward the core of your question. Also, some of you may know that in the U.S., when Roe versus Wade was first decided on the abortion rights in 1973 and then developed through Casey and other cases, there were people, including people on the left, who said, we're going too fast, it should be slower, states are working this out on their own, you're just adding fuel to their anti-abortion movement, So that's part of, we've heard these arguments before, obviously. So this is, let me say what I can say. I'm not a historian, I'm not a sociologist, so just to be clear about that. I think that my meta thinking about this is that unless we are going to be pretty categorical one way or the other, that is to say that once we've established these anti-discrimination norms, they apply, or religious and similar groups get to have a broad exemption almost all the time, I think we have to weigh other factors about the source of the discrimination, the way it is expressed, the way that the groups in question are playing themselves out politically at the moment. I mean, I would have to work this out, and if I were to do it, I'd probably do it with a sort of lawyer historian type, or like a Reva Siegel type, for those who know her work at Yale, or someone like that. So my instinct in those two sentences, and is that the gains of the LGBT, no, I'm a straight guy, so maybe I just don't know it, to be clear about that. Maybe the gains, I think that the gains of the LGBTQ movement over the last generation have been extraordinary, both in terms of key US Supreme Court cases, in terms of just sort of on the ground, as it were, sort of in the culture, that there are certainly pockets, I'm sure, of homophobia, but I feel like the cake baker at this moment is the more put upon minority. That's what I'm trying to say. Now, I don't have proof of that. But the meta point is, can we do this kind of jurisprudence? Can we sort of say, we're not going to be categorical, we're going to talk at each moment about who the more put upon minority is? And do we trust, getting back to one of Mila's questions, or do we trust courts to do this? Which is or is it your question? So it's Justice Stevens' question, the guy I clerked for. It was his big concern, was we just don't think government officials can get this right on a case-by-case basis, and so we should give up on it. So that's sort of, Ned, did you have another question? Or other people? I mean, I'm happy to continue.
I can follow up if there's, I'll just follow up with a very quick, short one, which was, and I wonder, this is why I said that maybe implicit there might be that the religion is a special category, because the cake baker is, it's for religious reasons that they have this objection.
Yes.
And so I was just, and it's because I work in security studies. So I was just looking into the Aryan Brotherhood of Texas, this prison gang organization that's also a street gang that filed for to be a religious organization. And so it was really quite cynical for tax reasons, but it's a religious organization, and presumptively, as the Aryan Brotherhood, they can make racial discriminations or it would be the kind of freedom of conscious kind of decisions in terms of who they serve and who they don't.
Yeah, that I wouldn't want to rule in favor of, as a balancer that I would balance against them. And then your question is going to be, is there a principled reason for balancing?
Exactly.
But the issue of deciding what counts as a religion and what doesn't, if we're going to do this exemption accommodation thing, is inevitable. I mean, there are cases in the US trying to deal with this and sort of saying yes to most, but no to some. No to I forget the name of the case, the guy who was just like smoke weed every day guy, and I'm the church of the cannabis smoke weed every day guy, and you have to give me an exemption. And the court said, you're not really a religion, you're just doing this to get an exemption. And so if you're like Justice Stevens, you think we can't consistently enough adjudicate these things. But I'm more of I'm by disposition a balancer and think we can get enough of them right, so.
Thank you.
Hi.
Hi. At the risk of oversimplification.
And what is your name, sir?
Oh, my name is Sam Goldberg. I'm a retired historian.
Hi, Sam.
At the risk of oversimplification, you seem to be modeling your argument on Niels Bohr and his principle of complementarity.
Okay, tell me.
Namely, that light can be either a wave or a particle. You're suggesting that both have relevance, both the particular argument as well as the more general one, depending on the context. And you seem to say that we have to look at the harm that is done either way and rule in favor of the lesser of the evils. But my question here is, how do you measure and who measures what is more harmful and less harmful if that is the way we have to resolve the issues?
So that's a great question, Sam. And by the way, my mother's maiden name was Goldberg, so maybe we're related. Her mother was Molly Goldberg from Waterbury, Connecticut. Do you know any Goldbergs from Waterbury, Connecticut? That's right. And by the way, I should mention, I wasn't thinking of this. Today would have been my grandma Molly's 112th birthday, so that's just relevant to this whole thing. So this is connected to this point about who decides. Let me say another word about this who decides point. One of the arguments for people who have argued for judicial exemptions and against this Smith decision, which is this leading decision saying there's no free exercise right for exemption, one of the main arguments against it is that state actors are deciding all the time. They're deciding in what laws they pass and what laws they don't pass, in what accommodations they put into the laws and what accommodations they don't put into the law, in deciding that the clerical positions in religious institutions are exempt from anti-discrimination law, but not other positions. And so I guess part of me feels like there's always state action making these decisions, and that therefore I'm more comfortable with saying that we could be making them in case-specific ways. The other part of your question is true. I think that in the end, the balancing of harms is inevitable, and that in many ways the hardest, I say the hardest question is the question of dilemma of liberal pluralism. Another way of putting it is the hardest question is what harms are properly regulable in the liberal state, and that's a hard question even if you're not doing this kind of law. If you're doing any kind of constitutional law, that question is very tough. Yeah.
My name is Neil Wolf. I'm a lawyer from the United States and working to complete an LLM here at the Institute of Air and Space Law. And I'm very interested in your discourse about expression under the First Amendment. I recall that when I was in the classroom teaching as an adjunct in a doctorate of education program at the university, like yours, a Catholic university, though much less well-renowned than yours, and I was general counsel, so I was holding forth on
of the university?
Yeah.
Okay.
While I was teaching. And it was an awkward line to straddle sometimes. And later I realized that what I was trying to do was encourage students to speak. And I'd ask them provocative questions, worrying about revelation of attorney-client privilege for pending files on my desk. But I tried to draw out wherever I could and eviscerate reticence to hold forth on their own part. And I've always wondered about whether freedom of expression in the United States presumes too much about individuals bringing to the marketplace of ideas a willingness to talk. Some cultures, I mean, I'm old enough to remember the drive-in theater as well as the old cliche, children are meant to be seen and not heard. And so there's, what I'm getting at is in some cultures and some subcultures within the United States and Canada and other parts of the English-speaking world. For example, a middle-aged lawyer who comes to Quebec to study at
Sounds
McGill
like the beginning of a joke. A middle-aged lawyer comes to Quebec
and doesn't speak French is going to lack certain freedom of expression. Now, that was by choice. But when we burden expression in favor of other pluralistic rights, are we presuming that there is an inclination, a tendency, a willingness to express in the first place?
Neil, right?
Yes, sir.
What school were you at?
Benedictine University, Lisle, Illinois, County of DuPage.
Okay, I lived in Chicago for 3 years. We all have these Chicago connections. It's such an interesting question. When I do the first couple of classes on freedom of speech, and we talk about the free speech principle and what are the justifications for it, and we talk about one of them being sort of personal liberty or autonomy. It's slightly different. And one of the things, I try to push back on all of them. The great book on this is by Fred, if you're interested, Fred Schauer, S-C-H-A-U-E-R, has a book called Free Speech, A Philosophical Inquiry. Fred has since become one of the leading scholars of both speech and legal theory in the U.S., but so he lays out all these arguments and then pushes back against all of them. I say to my students, look, I say, you're all law students. You're all here because you like to talk or you like to write or all of the above. But there are a lot of people for whom, they'd rather just, ride their motorcycle or shoot their gun or smoke weed every day or grow their crops or blah, 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 and for whom speech is not such a big deal. And so I appreciate, I don't have much to say other than that. I appreciate what you're saying, and I think there's classism is too strong, but there is something built into the free speech. Let me put it this way. Sometimes I think that some of the justices who have like a special room in their heart for freedom of speech, but not for any other freedoms, just have it because they're, well-trained lawyers and they're familiar with that. I don't want to name names, but anyway, okay. Yeah.
Hi, my name's Dave. I'm just an interested member of the public. I'm interested how your analysis might change when our efforts to preserve pluralism potentially impact not just our liberal impulses, but also pluralism itself. For example, in the analysis of the baker of cakes, you mentioned that there's no dearth of other bakers, but there could have been. And in that case, there could have been a dearth of wedding calls and a dearth of florists. and of other places that would allow a group to express themselves as part of society, to basically, it would become a problem for us being pluralistic itself. And I wonder whether you think that's legitimate to consider when weighing harms, and if so, does that make our decisions oddly contingent on the rarity or popular?
Yeah. So let me just ask you a question, a very good question. So just to tee it up a little bit. So let's say we have case A, there's one baker, it's a rural area. Case B, it's a town or city with many bakers, right? And you're wondering whether we might resolve these cases differently. That's the question.
At a different point in time, maybe.
Yeah, I mean, you're not arguing, you're just making a question. So, so to the, the doctrinal answer is, to the extent that the harm to the same-sex couple is ultimately about equality, the cases should be resolved the same. To the extent that we can talk about substitutes and do a kind of market analysis, then the cases should come out differently. There's a professor, I think he's the dean at St. Thomas Law School, which is a religiously affiliated law school in the Twin Cities. I think it's in St. Paul, Minneapolis. His name is Robert Vischer. He's a conservative, interesting conservative guy, and his whole book on this is in large part a market argument, that it could be contextual and contingent. Which from a religious Catholic is interesting, because he's giving, half of the cases not to the baker, So my instinct is to want to adopt a market argument, but I realize that the equality, dignity harm is so strong that it's hard to ultimately do it.
Yes, my name is Alec Chrisman. I'm a first-year PhD here in political theory, and thank you also for the very informative talk on an issue I'm very, very interested in. I do have one just brief clarifying question about your position and the state of current U.S. First Amendment law and how those two relate. In your talk, you made reference to certain ideas about balancing certain harms of speech against the importance or the value of speech. And I was just curious, in my very impoverished pop understanding of the First Amendment, I thought that United States versus Stevens outlawed balancing.
So what's your name again?
Alec Chrisman.
And you're Canadian or American?
I'm American.
And I'm grilling him a little bit here. I just wanted, because you've hit on the exact right case, so that's good.
And I was just curious about that. Like in United States versus Stevens, as I understood it, balancing tests regarding the First Amendment were set aside as a factor of U.S. law. How different is that? An accurate state of U.S. law, and how different is your position from that?
So I spend a bit of time on this in my class. So U.S. versus Stevens is a fairly recent case. Chief Justice Roberts wrote the opinion for the court. The very brief background, the Congress had passed a law called the Animal Cruelty Protection and Prevention Act. It was meant basically there's this weird subculture of people who like stamp on animals with their high heels and kill them, and then people watch them to get off. I'm totally serious. And so Congress wanted to not only go after the actual stamping and killing, which everyone agrees legislatures can go after, but the videos that were being made and sold of these. They wanted to go after the video distributors and sellers also. And the problem is the law was written more broadly. It was involving sort of any killing of an animal, which could include hunting and include like slaughter for food. And the court eventually said this law is just too overly broad. It could cover way too much stuff that we want to protect. So that was the holding. Now, there are a couple of key pages, at least in my case book, written by Chief Justice Roberts, where he talks about an argument that the U.S. had made. And the argument, I have to give a little bit of, I'll try not to make this go too long. So in the U.S. free speech law, there are certain categories of speech where the government is allowed to regulate based on content subject to certain balancing tests: incitement, fighting words, libel, obscenity, child pornography, commercial speech. The government had come to the court in this case and said a few things. They said, first, this should be a new category. Animal cruelty should be a new category. Secondly, even if you're not going to adopt this as a new category, which the court didn't, you should do a general balancing of sort of costs against benefits. And it was as to that Roberts had all of his fire. And so my view about this is that if we're just talking about costs and benefits in a sort of economic sense, then I think he's right. That's not the sort of way the First Amendment is done. But if we're talking about understanding the value of speech versus the harm from speech, I think the court does it all the time. Legislators do it all the time. The court does it all the time. You know, when I get to that point in the case, I remind my students of all the other cases where we've seen the court doing this. Now, sometimes the court says it's doing it, which I like. Justice Stevens has a famous opinion in a case about the zoning of adult movie theaters, which they uphold, where he says, none of us would march our sons and daughters off to war to see specified sexual activities at the theater of their choice, because that was the name of what Detroit was regulating. Stevens was very expressly saying, of course we weigh harm against value. So my view is that it's inevitable and that Roberts is overly wrought in his argument to the contrary. Okay.
Thank you very much.
I'm glad to have an opportunity to do a little First Amendment of speech stuff. Okay.
Stephen Scott, I'm a retired member of this faculty. The U.S. Supreme Court has, I believe, this week been hearing a case in which there is a challenge to a California statute requiring that clinics, pregnancy clinics, disclose the nature of their services. And it appears to have emerged an argument that, for example, some clinics which are basically offer no abortion services and are anti-abortion, nevertheless have advertising in which they show nurses in uniform. Obviously, one would suppose to lure people there who might think they are going to have abortion services. So I was wondering what your take is on this case, and how you think it should come out and what you think the U.S. Supreme Court will do.
And what's your name again?
Stephen Scott.
Stephen, thank you. I'm so bad with names. I mean, even if I have a seating chart with my students, I'm just, you're Victor, right? Victor's easy to remember. Okay, so a little back. There are 3 compelled speech cases at the Supreme Court this term, and one of the areas I've written in, so I'm sort of excited. There's the cake shop case where the main argument that Jack Phillips is making, because this precedent is sort of excluding his free exercise claim, is that by having to bake a custom-made cake for a same-sex couple, he's being compelled to express his support for same-sex marriage. Thousands of pages have been written on this. There's another case about whether so if you're a member of a public employee union in many settings, some of you may know labor law, I'm not an expert. In many settings, it's called, I think, an agency shop, where you don't have to be a member of the union, but if you're not, you at least have to pay fees in lieu of union dues. Years ago, the court held that to the extent a portion of those fees goes for union ideological speech, you have a compelled speech right to a refund, but to the extent the portion of those fees goes to collective bargaining activity for the whole unit, you don't, because otherwise you'd be a free rider. As to that last piece, the dissent said, wait a minute, in the public sector, we're talking about teachers' unions and firemen's unions and police unions, even in the collective bargaining, there are always big issues of public concern coming up, and if you're not a union member, you shouldn't have to pay for that bargaining. That that holding is being relitigated now and almost certainly is going to go in the direction of the non-union members. That is to say, they can't be compelled even to pay for the collective bargaining activity. That's case 2. Case 3 is this case where I need to study it more carefully, but basically there are 2 laws in California. One is for places that have, I think, proper licensing or medical licensing to have to put up a sign that says where you can get other types of services, including abortion services. And that part is almost certainly going to be struck down as saying it violates the right of these anti-abortion clinics, which are otherwise properly operating, to not have anything to say about abortion. The other part of the law, though, the other law is for non-licensed clinics to have to put up signs basically saying we don't have doctors here. And that seems more likely to be upheld on the ground that it's sort of truly factual, non-controversial, and goes to basic health issues. Underlying this is this question of the record that I'm not familiar enough with, of how much, in fact, has been shown or has been alleged about sort of misrepresentation. And I think this case is being decided on summary judgment, which means there hasn't been a trial, which means I think the court could well just send it back for trial and say we need to know more about this. So, but it's the 3 cases all on compelled speech, which is a big issue in U.S. First Amendment law. So, thank you all so much. I appreciate it.
Thank you very much to Professor Greene and to the audience. And now I would ask you to join us in a reception When you come out of the moot court, make a right, and it'll be at the end of the hall after a few thresholds. Thank you very much.
Thank you, Victor.